Dear Lord, we give you thanks for giving us another day. Before the start of today's session of Parliament, we ask your blessing on the members of this chamber and all who support their work. May they be led by your Spirit in the decisions they make. Grant them your peace as they steady themselves amid the pressures and persistent problems and challenges. All through the week, may they do their best to find solutions to the pressing issues facing our nation and its people. As we remember the words of our anthem, the Lord has been the people's guide for the past 300 years, and with him on the people's side, you have no doubt or fear. So Lord God, what we know not, teach us, what we have not, give us, what we are not, make through Jesus Christ, our Lord. Amen. To the Lord's Prayer. Our Father, who art in heaven, hallowed be thy name. Thy kingdom come. Thy will be done on earth as it is in heaven. Give us this day our daily bread, and forgive us our trespasses, as we forgive those that trespass against us. And lead us not into temptation, but deliver us from evil. For thine is the kingdom, the power, and the praise, forever and ever.
House is now in session. Minutes.
Mr. Deputy Speaker, I beg to move that the minutes of the meeting held on Monday, 18th of February 2019 be deferred.
Question is that those minutes be deferred. All members in favor say aye. Those against say no. I think the ayes have it. They say be deferred.
By Honourable Deputy Speaker. Messages from Her Excellency the Governor General, petitions, papers, government notices, private members notices, notices of questions, reports from select committees, first readings of bills. The income tax. Okay, go. Next one. First reading. Mr. Deputy Speaker, I'd like to move the first reading of the Income Tax Amendment Bill 2019. Who's that? Let's have him. Minister Deputy.
Question is that this bill be read the first time. All those members in favor say aye. Those against say no. I think the ayes have it.
Mr. Deputy Speaker, I beg to move the first reading of the Tax on Remittances Repeal Bill 2019.
Second. Seconded. The question is that the bill be read the first time. All members in favor say aye. Those against say no. I think the ayes have it.
Statements by ministers, congratulatory and or obituary speeches, personal explanations, motions for leave of absence, oral replies to questions, notices of motions for the adjournment of the House on matters of urgent public importance, orders of the day. Mr. Deputy Speaker, I would like to move the suspension of Standing Orders 6, 16, 18, 20, 28, 13, 42, 5, 43, and 44 for the remainder of the day's sitting.
Question is that those standing orders so mentioned be suspended for the remainder of the day's sitting. All members in favor say aye. Aye. Those against say no. I think the ayes have it. Government business is now the order of the day.
Government business. Order number 10, sir. In the name of the Honourable Attorney General and Minister of Legal Affairs, to move the second reading of the Proceeds and Instrumentalities of Crime Bill 2019.
Member for St. Joseph, Honourable Member for St. Joseph, Attorney General.
Mr. Speaker, we are gathered at Parliament today with a piece of legislation that, though not seminal, it is a piece of legislation that is vital in terms of our effort at fighting and suppressing criminal activity in Barbados. For the most part, sir, when we talk about fighting and suppressing criminal activity, people will form the impression that we are enacting another law which will create a raft of new criminal offenses. In truth and in fact, Mr. Speaker, that is not the nature of the bill that is before Parliament today. This bill, Proceeds of Crime and Instrumentalities Act, or as it's properly called, Proceeds and Instrumentalities of Crime, is intended, Mr. Speaker, to strike at essentially those assets that are in the possession of the criminal element of our country, where those assets are either themselves the proceeds of crime or are intended or have been used in the commission of crime or in unlawful conduct. Now, I said, Mr. Speaker, that it is, while it is important, it isn't seminal. For those of you who would have been looking at the area, you would know that we have on our books a Proceeds of Crime Act, and that this Proceeds of Crime Act was enacted in 1990. And it did receive some slight attention of Parliament in 1998 and in the year 2000. The year 2002, sorry. And this act, sir, even though we are about to repeal it today, is instructive in setting the context in which any proceeds of crime legislation is enacted and would operate. And if you would permit me, Mr. Deputy Speaker, to refer to the principal objectives of the current Proceeds of Crime Act, enacted first 29 years ago. And in Section 2 of this Act, it says, the principal objects of this Act are to deprive persons of the proceeds of and the benefits derived from the commission of scheduled offenses, to provide for the forfeiture of property used in or in connection with or for the purpose of facilitating the commission of scheduled offenses, to provide for the forfeiture of property derived, obtained, or realized directly or indirectly from the commission of the scheduled offenses, to provide for the making of confiscation orders in respect of property shown to have been derived, obtained, or realized by a person directly or indirectly from the commission of the scheduled offenses, and finally to enable law enforcement authorities
to trace such proceeds, benefits, and property. Mr. Speaker, those important elements are not being discarded today. In fact, those important elements inform and continue to run through this new bill that we're presenting to this chamber. But the obvious question would be, if the objects and purposes of the existing bill are still very much valid and relevant, very pertinent to how we deal with proceeds of crime, why would this Parliament be seeking to amend it? The answer is given simply, though it is not necessarily a simple answer. I took the pains to read these particular objectives, and you would have noticed that the term "the scheduled offences" was repeated in that description. So, to deprive persons of the proceeds of crime, benefits derived from the commission of scheduled offences. The scheduled offences, Mr. Speaker, to the existing Proceeds of Crime Act are related to drug offences and also offences either in funding terrorism or committing acts of terrorism. So the proceeds of crime legislation that we have today in Barbados, and that has been here for the last 29 years, was focused solely on proceeds from drug crime or terrorism related. Now, I think we all know that while terrorism has the capacity to be funded through any country in the world and to take place in any country in the world, and while members of the public would know that in the region of 140 Trinidadians journeyed to Syria to fight for ISIS, our circumstances have not demonstrated that there's a high risk of either terrorist financing or terrorism activity in Barbados as compared to other jurisdictions. And they say as compared to other jurisdictions. So that the proceeds of crime legislation that we have, if you put terrorism-associated issues aside, effectively look only to proceeds of drug-related crime. Now, Mr. Speaker, that is a glaring deficiency. And perhaps when it was enacted in 1990, other kinds of criminal activity were not looked at through the scope of the 1990 Parliament and the 1990 law enforcement officials. But we've strayed very far, Mr. Speaker, from a Barbados of 29 years ago to a Barbados of today, where there is an increased sophistication among the criminal element. Almost, Mr. Speaker, you could say a financial maturity among the criminal element. Let us not fool ourselves. There were times past when you would describe a person as a criminal, and it was as simple as that. But a lot of people in the 29 years have morphed from being out-and-out, straightforward criminals to being criminals clothed in the garb of respectability. And some of them live in the heights and the terraces, in houses procured by ill-gotten gains, and driving cars procured by ill-gotten gains, and they also operate commercial enterprises all across Barbados. From things as small as corner shops and bars to high-profile retail enterprises in Bridgetown. The source of the proceeds of crime are definitely not limited, Mr. Speaker, to the drug trade. In fact, the sophisticated level at which our criminals in Barbados appear to be operating would tell us that there are some who may influence the drug trade, but who keep out of it. And we now have firearms coming into Barbados that themselves represent a source of revenue for the criminal element. So let us look at the logistics of it, Mr. Speaker. The existing legislation focuses on drug-related offenses. But what happens, Mr. Speaker, if the particular peddler, the particular merchant, doesn't sell drugs, doesn't grow drugs, is not a dealer in drugs, but is instead a dealer in firearms? Which surely, from all that we are hearing, is as lucrative, though perhaps more immediately dangerous. But a court in Barbados could only be moved to confiscate the assets of an individual who was found importing marijuana. But they couldn't confiscate the assets as a result of that individual selling guns. In fact, arguably, Mr. Speaker, you could procure the proceeds of crime insofar as the drug activity is concerned, but whatever resources would have been garnered by the sale of firearms or by money laundering or many of the other lucrative criminal operations, you can't touch those. Now, Mr. Speaker, I don't fault the 1990 Democratic Labour Party administration. They dealt with the situation as Barbados was faced at that time. I recently indicated to this chamber that in the 80s decade, we had a total of 42, I think it was 42, firearm homicides in a whole decade. In a whole decade. In recent times, we've had that many in 3 or 4 months. So the point is, as I said, I'm not blaming a former Democratic administration. They dealt with the landscape as it was at that time. But today's landscape is very different, sir. Today, the individuals who will earn their keep by laundering money, who will earn their keep by selling guns, who will earn their keep by being involved in human trafficking. So the point is, sir, a society has to ask itself, why drug offenses and terrorism offenses and no further? Are the other forms of criminality somehow to be more favorably looked on by our society? Should we only tackle the fellas peddling cocaine, but the individuals who have a racket of stealing cars and selling the cars and the parts, somehow or another, we shouldn't look at those? So, let us face it. There can be little or no justification for maintaining on our books a statute that was so limited in scope that it only covered a small percentage of the criminal activity. So we needed to change it. But there were other important considerations, Mr. Speaker. This existing piece of legislation, and we're passing a new one, but pardon me for taking the time to demonstrate to Parliament why we've needed to go in this direction, because where we are going is significantly different to where we are now. This particular statute says that the DPP can apply to the court for a forfeiture order where a person is convicted of an offense. So the existing framework only bites, firstly, in those limited cases, and secondly, where the individual has been convicted of an offense. No, sir. There are any number of circumstances which could prevent an individual from being convicted of a criminal offense. May have absconded, may have died, he may even have gotten off. He might have been found not guilty. But nonetheless, there would be clear knowledge that that individual has been engaged in unlawful conduct. And the current international trend, which is the direction we're going in, is that where the authorities can establish that you have been engaged in unlawful conduct and that that unlawful conduct is the source of the assets, then, Mr. Speaker, you are entitled to have those assets forfeited. And you know, I hate to go back, but of all the things that I mentioned, I didn't even mention crimes like corruption. And permit me just for 30 seconds to go back to there, because in a society that has suffered so much under corruption, our existing Proceeds of Crime Act does not allow the authorities to seize the proceeds of those corrupt acts. Doesn't. So individuals who've been engaged in acts of corruption but have palatial residences, drive big fancy cars, own restaurants and bars and other kinds of enterprises, build apartments up and down Barbados, all arising out of taking bribes. The existing law says we have to, as the English would say, doff our hats and say, on your way. But that is to take us back a little early in the debate. So, under the existing arrangement, there must be a conviction, while the direction that international trends and the direction that I am commending to this Parliament is that we have a mechanism in place which can allow the Crown to seize an individual's assets in circumstances where there may have been no conviction. And there are any number of reasons why there might have been no conviction. So, Mr. Speaker, by opening remarks then, I want to say to this chamber that today's criminal often distances himself or herself from the individuals who are out there doing the drug running, who they're doing the shooting and the muggings and the stabbings. Today's criminal is frequently clothed in a veneer of respectability and attends the cocktail parties and eats lunch at the Hilton and so on, while there is a deep underbelly of criminal activity that provides the source of those funds. So, in those circumstances, Mr. Speaker, it is important for us to go after those other individuals who, through their resources, ill-gotten as they are, have been able to put up barricades which sees it difficult to prosecute. So, Mr. Speaker, an individual who, let's suppose, involved in the drug trade, but sets up a retail business, whether it is selling corned beef or camisoles. But that retail business, funded by proceeds of criminal activity, will be visited by people in town, and they can go and they can shop and so on. It's money laundering too, Mr. Speaker, because you're cleaning dirty money. But that individual, as I said, looks and is treated by our society as being an upright businessman and an employer of Barbadians. I know, sir, the Prime Minister frequently says that we have a Kadir society, because you say Kadir, left alone. He employing people. He paying rents. He is driving the economy. But in those cases, Mr. Speaker, the gasoline that he might be using to drive some parts of the economy, sir, is garnered from the blood and suffering of Barbadians. So, new landscape, new laws. And I'm commending to this chamber today the proceeds and instrumentalities of crime. Proceeds, self-explanatory, because the proceeds are those things which emerge out of. And instrumentalities, those are the things that are used in the carrying out of unlawful activity. So don't, as young people say, get tired. We have proceeds of crime legislation today. So it is not that the Barbados Labour Party is trying to visit the landscape of Barbados and trying to take away people's property as a new spectre on our landscape. It exists today. What our administration is seeking to do is to correct the obvious and absurd defects and deficiencies, and also to put a better framework in place. But at the outset, I must also tell the chamber that while we are expanding the opportunities for seizing ill-gotten gains, the protections under the law are also enshrined in the statute. So, with those opening remarks, sir, and while I suppose the chamber doesn't necessarily like to go into the minutiae of any particular bill, and this bill is a bit on the long side, and I don't propose to do that, but I propose to divide the rest of my presentation into perhaps thematic areas and look at the particular clauses in the bill and try to demonstrate how these clauses work. The first thing I want to say is that this bill is divided into two areas. One area dealing with the seizure as a result of a criminal process, and the other relates to seizure as a result of a civil process. As to the criminal process, this bill establishes a regime not too different from the existing one, where a prosecutor, upon a conviction, is able to apply to the High Court for a seizure, a forfeiture, a confiscation of those assets which you either have acquired from criminal activity or which you use in the criminal activity. So let's talk about the simplest part. A person who uses his motor car as a getaway car from a crime, or as the vehicle that the gunmen used before they committed a crime, that is an instrumentality. And so long as there is criminal activity for which the person is convicted, you can go after that. But equally, sir, in a situation where an individual commits, let's say, an act of fraud, embezzles money, takes that money and buys a house with it, upon being convicted of that crime, the prosecutor is able to say to the court, Judge, I am applying to have this particular asset seized. So the first regime deals with consequential applications to convictions. And I'm sure that members of this chamber, astute as they are, would be saying, but what happens if you appeal and get off on appeal? In those instances, any forfeiture is void. So, if you're convicted of embezzlement and on appeal you get off, the assets that the Crown would have taken from you would be returned to you. You're also entitled to receive compensation as a result of what would evidently have been a wrongful act. So there are tremendous safeguards. The individual has to be served notice of the application by the prosecutor, and he or she would have the opportunity in argument to demonstrate to the court that in fact the house was not the proceeds of crime, but it was a house that he built over time, utilizing borrowed funds. Maybe he borrowed $20,000 from his mother, maybe he borrowed $80,000 from the bank. But as long as he can establish that the residence, that building, that whatever it is, was not the proceeds of the crime, then he has nothing to fear. The court simply would not be able to make an order because it must first of all be proceeds of crime. And there is a court process which allows the individual to defend the allegations and to vindicate his right to own the property. That, Mr. Speaker, is covered in the first provisions of the bill, or I should say the first half of the bill. And the court needs to be satisfied, not necessarily that the particular asset was the proceeds of that particular offense, but that it was the proceeds of something associated with it. The prosecutor will have to apply for a confiscation order. The prosecution must give the defense no less than 14 days notice of that application, and the defendant in clause 14 of the bill is entitled to appear and to adduce evidence at the hearing of the application, and the court would make the decision. So, while that is done in the context of a criminal proceeding, there is something that is very important for me to point out. The standard of proof in these proceedings is a civil standard of proof. Now, don't want to take anybody back to my law school days, but in the system of justice that Barbados operates under, in a criminal case, the standard of proof is beyond a reasonable doubt. I mean, we've all seen that on TV. Beyond a reasonable doubt. And it therefore requires, in the case of a conviction, that in order to be convicted, you must feel sure that the person committed the criminal offense. I believe that's still the current direction to the juries. But in respect of seizure of the assets, sir, a lower standard of proof will be put in place by the statute. And in this case, the standard of proof required is a civil standard of proof on a balance of probabilities, which, put in another way, says that it is more likely than not that you acquired it as a result of criminal activity. So, with a conviction, beyond a reasonable doubt. But when it comes to trying to determine whether, in fact, you own the asset and whether if you can establish that you own, that the individual owns the asset, in order to be able to be satisfied, that it was the proceeds of crime or was used itself in crime, we are using a lower standard. Now, individuals may ask why. Well, there's the answer that is grounded in solid jurisprudence, and the answer is, in relation to an individual, you require a higher level of proof. So where the court is acting against the person in personam, you must use a higher standard of proof. But where the law is acting not on the person but on property, also known as in rem, then a lower standard of proof obtains. Now, I don't know if there's any point repeating that, sir, because I'm not so sure how many members of this chamber appreciate it. And I don't want to be the one to say, take it from me, because I know. But appreciate just the slight difference, that where, for example, the liberty of the subject is concerned, you want to apply the highest possible standard. But where it relates to property, we are applying the civil standard. And this is, we don't have locally grown jurisprudence on this, but the fact is that it is the standard stipulated by the statute. This statute has been followed. In fact, our statute is largely based on the UK statute, which has been litigated in the EU, in the European Court of Human Rights. We are looking at this legislation is found in other countries in the Caribbean, and it follows the same principles. In fact, sir, legislation of this kind is across the world known as civil asset recovery legislation, because it is done along the lines of a civil proceeding. Now, let us look, though, at the other side of things. Mr. Speaker, the powers of the court are exercisable in relation to any property. And for those of you who wish to refer to the statute, you can look at 69, and Clause 69 of the bill says this part has effect for the purpose of enabling the recovery authority to recover in civil proceedings before the court property which is or represents property obtained through unlawful conduct, property used in or in connection with or intended to be used in or in connection with unlawful conduct. And it goes on at 69.2 to say that the powers conferred by this part are exercisable in relation to any property, including cash, whether or not proceedings have been brought for an offense in connection with the property. So this particular clause covers off a lot of areas. And the last one first, whether or not an offense in connection with the property has been brought. So we don't need to have brought or charged an individual with any offense. Secondly, it is any property including cash. Now, in the course of our discussions on this bill, there have been a lot of things asked. So what happens if you sold drugs and took the money and built a house for your mother? Proceeds of crime. If you fix up your mother's old house, that part, that interest that you have by fixing up your mother's old house, proceeds of crime. And that is what we have to remember. The sophisticated criminal tries to find all kinds of ways to clothe these funds and assets with an aura of respectability. But this statute allows the court to go after it wherever it is, however it is. In fact, Barbados has been asked by the English courts in relation to a Barbadian who was charged and convicted in England of various drug offenses. And the government of Barbados has been asked to assist in recovering his assets in Barbados. But what do his assets in Barbados consist of? He took some of the proceeds of crime and fixed up a family home in Barbados. But because you fix up a family home, it doesn't mean that that asset is not tainted. That asset is tainted. And the powers of the court allow for, in certain circumstances, for the court to try to recover out that particular interest. No, you can't sell half the house. You can't sell the upstairs or the downstairs part. But these are things that the courts deal with every day. Every day people fight property disputes. And in fact, as you think about this particular element, the civil recovery part, think of it very much along the lines where two people have a dispute over property. Myself and the member for St. Peter may have a dispute over property. And he has to prove to the court that it is his, and I have to prove to the court that it shouldn't be his. I have to prove to the court how I say he got it. He has to prove to the court how he says he got it. And he may say, I now own this property with my wife. All of these scenarios are scenarios which present themselves in civil asset recovery. Because when the Crown, think of the Attorney General, the Office of the Attorney General as being just another party to a civil action. The Attorney General will be bringing an action saying, you have no right to that house or to that car. Mr. Deputy Speaker, that is what the courts decide on every single day. They decide it every day. They decide it in the context of family law matters where people fight over houses. They decide it in the context of contract matters where we say you put in this, I put in that, and so on. And this scheme also allows and will allow for third parties to come and say, hold a second, I have an interest in this. So take a case. An individual decides to lend somebody else money and take a mortgage over it. And the person who borrowed the money and gave the mortgage did it innocently. After all, they wanted to buy something, they wanted to finish it, did it completely innocently. But the money which was used to fund it might be proceeds of crime. After all, the criminal himself is trying to legitimize his day-to-day activity, and he can start lending out money to various people. He might sell them materials, all kinds of things. But the innocent party under this statute, and I can refer you specifically to the clause, but I'll get there, I'm getting a bit ahead of myself. The innocent person is able to say, no, I did this transaction bona fide at arm's length, and I'm innocent of any connection to his criminal activity. These are the kinds of things that the courts will be deciding in this regime, but it is not dissimilar to the day-to-day business of the High Court of Barbados, where disputes over property are concerned. So please don't think that what we're asking the court to do now is anything alien. They do it every day. They've been doing it every day for the last 300 years. It is just that the subject matter now that is being fought over between the Crown and an individual that the Crown believes has been guilty of criminal conduct. Now, as I've said, there are a number of situations where an individual might not be charged, but I want to make this point. In every instance, the prosecution of a criminal remedy is paramount. So this is not a case where where members should feel that this is giving a fella or a lady a way out of a conviction. It is not, and it is never going to be a choice between either I confiscate your property or I charge you. That's not the regime that we're looking for. In every single case where a conviction is possible, then you must be charged and you must be tried. Because at the end of that process, if you are convicted, we still have the opportunity to seize the assets. So criminal proceedings will always be given preeminence. But as I said, in circumstances where criminal proceedings are not possible, in circumstances where you might not have enough evidence to support a criminal proceeding, but you have enough evidence to satisfy the courts on the balance of probabilities, that is a perfect case. That's a perfect case. And therefore, it is open to the recovery authority, as I mentioned, that individual is the Attorney General, to use this mechanism to achieve civil recovery of the asset. Now, what kind of time frame are we talking about? Well, I can tell you, and I ask members to look at the combined effect of Clause 106 and 107. 106 says that proceedings shall not be brought for a recovery order in respect of any recoverable property after the expiration of 20 years. 20 years, sir. Found it? 106. Right, Clause 106. So the limitation period is a 20-year period. 20 years after you acquire the proceeds of crime. 20 years, sir. 106. Now, 107 does something which is not ordinarily the case, because 107 seeks to give retrospective or retroactive powers. So that Section 106 says you have 20 years after the ill-gotten gains are I don't want to say earned, because you can never really earn ill-gotten gains, can you? But after you acquire the ill-gotten gains, you have 20 years. But 107 says that for the purposes of determining whether property was recoverable at any time, including a time before the commencement date of this act, this part is deemed to have been enforced at that time and at any other relevant time. So what this says, sir, is that, you see that 20 years? That 20 years is not only looking forward, that 20 years, Mr. Deputy Speaker, looks backward. So a person must not take comfort in the fact that they already have proceeds of corruption as at the date of this act, and because the ordinary course of law says that a statute looks ahead, that they can keep it. No, sir. No, sir. Not in this going down. Not under this statute. So the recovery authority, in cases, well, in every case, as long as the factual matrix exists, will be able to go back, sir, and recover the proceeds of corrupt dealings. Now, you know, sir, we came into government perhaps on the wings of a populace that had been beaten and broken for 10 years by an administration that long showed that they didn't care. And one of the things that oppressed and debilitated our country was this thing about corruption. And you know, sir, I keep saying that these things do not happen overnight. Everybody telling me, man, you ain't locked up the body yet. And I keep saying that the investigation of crime, especially white-collar crime, is painstaking and takes a long time.
Of course.
I had a meeting yesterday with an overseas investigator looking into payments that were made as far back as 2009.
10 years ago.
As far back as 2009. And another case that we discussed was as far back as 2011. You know, the thing about white-collar crime is, sir, they don't leave fingerprints. And people don't like to come forward and squeal. Things are done in the dead of night. Paper bags with money in them pass hands. People don't write checks saying, this is the bribe money that I paid you. So it requires painstaking, meticulous investigation so as to be able to establish that you have enough evidence to substantiate. I know, sir, perhaps I say in the spirit of levity, but some of the people who say to me, man, I know. I said, well, if you know, come. If you know, come. And as, I don't know, sir, I don't know if it will be, I don't think it is it's an unparliamentary term, but when you tell them, sir, you know, they push back. all of a sudden, they know. But the job has only just begun. Be mindful of that. The job has only just begun. So for all of those people who somehow feel that they are immune from being pursued for ill-gotten gains, perhaps because they were not charged with any offense, or perhaps because the law is only now being passed today or during the course of the next week or so, you are absolutely wrong. Because this statute intentionally says we're going back 20 years. And in case anybody thinks that this is a Democratic Labour Party witch hunt, if we want a Democratic Labour Party witch hunt, sir, we would have carried back 10 years. If we wanted a DLP witch hunt, we would have carried it back 10 years. If there's one thing that I keep repeating, Mr. Speaker, Mr. Deputy Speaker, is that this is an administration that does not intend to hide from anything. And when we pass a law, nobody is to believe that we pass it, but don't expect to be caught by it. You know, sir, I do not know a more remarkable set of politicians who are committed to putting a framework in place that even though it might have a deleterious effect on them, they're still prepared to do so. I know that the leader of the opposition agrees. Because going back 20 years, will take us back, Mr. Speaker, to 1999. 1999. And by the time of the next election, part of the Barbados Labour Party administration could still be covered if we were to lose the next election. And when the time comes, if it comes, as these things are cyclical, that the Barbados Labour Party should lose the election, whoever is the administration then can come back and inspect us.
Yeah, as a matter of principle.
No, I don't know that you could want a better sign of good faith from an administration than that. That we are prepared to be held accountable for what we do, not just in the past, but also going forward. You know, the last administration passed an Integrity in Public Life Act. And they didn't proclaim it.
It was passed?
They passed it. We had select committees, so nobody could say that it wasn't given the fullest consideration. They passed it. I believe it was on our books, must have been for at least 6 or 7 years. Because they passed it during their first term in government. No, during the second term, because they would have died.
Yeah.
They passed it at the start of the second term in government, probably around 2013. Mr. Clark, it was around 2013? Mr. Clark is nodding his head, yes. Imperceptible movements, but he's nodding his head. They passed a law declaring that there shall be integrity in public life, and people in public life will have to do this and have to do that and have to do the next thing, sir. And then on the eve of the election, the then Attorney General, a member from St. Philip, was heard to say, we are going to proclaim it before the election. Never proclaimed. They passed the law, refused to bring it into force, and I can only assume, sir, that the reason they didn't bring it into force is because they did not intend for it to apply to them. They didn't apply for it to apply to them. When we were last in administration, we changed the Public Accounts Committee we enacted Public Accounts Committee legislation under the old regime where you just had the rules of the chamber, the standing orders. You needed the government to be able to form a quorum. And we said, no, this is wrong. Public accounts should really be the domain of an opposition. And even though we were in government, we passed a law which shifted the possibility of a quorum onto the opposition and independent senators. Now, that could have been used against us. But it didn't matter because it was the right thing to do. And sir, for as long as the Barbados Labour Party continues to hold true to those principles, that it is prepared to be bound by the highest possible standard, the people of Barbados will have reason to keep faith with us. So, we can talk about that all you like, but we are going back 20 years, even years of the Barbados Labour Party. Now, one of my colleagues asked me, well, what triggers all this? How do you get before the court to make this application? Well, let me say that the application is made by the Recovery Authority. The Recovery Authority, under this statute, is the Attorney General. Or perhaps we should properly say the Office of the Attorney General, because under our law, just because you say the Attorney General, it doesn't mean the Attorney General is going to go to court and do it. But what triggers this is essentially evidence. So it's not a question of who triggers it, it's a question of what triggers it. Evidence. You know, so there was a famous case called Shaw and the DPP, where it said the court doesn't care how you get the evidence, as long as you get the evidence. We don't care how you get it. You know, in the United States, there are rules. If you don't get this evidence properly, it can't come in. Not in the common law jurisdiction. We don't care how you get it, as long as we have it. So these proceedings are evidence-based proceedings, because the Recovery Authority must be able to satisfy the court that you own the recoverable property, and that the recoverable property had its genesis in unlawful activity. And as I said, you are able to come to the court and say, not true, sir. This property was acquired by me as an inheritance. I bought it with my hard-earned money, any of those kinds of things. And in that case, your property is invalid. Your property is invalid, sir. But the point is, if you can't establish that, then the Recovery Authority will succeed. Now, what happens when he gets to court? He asks the court, makes his application, it's served on the defendant in the case. And he can ask the court to make a freezing order. Now, a freezing order is exactly what it sounds like. A freezing order is an order made by a court which freezes the property in the hands of the defendant. So the defendant, as a result of the freezing order, has no ability to deal with the property until the proceedings are concluded. And I remind you again that that compensation is payable. So if the Crown loses, then compensation is payable to the defendant who is inconvenienced. So the property is in the first instance, it may not need to be, but it may be in the first instance frozen. But property is not always cash in the bank. Cash in the bank you would want to freeze. That's in the nature of an injunctive remedy, because if you don't freeze it, then the individual can just move it, convert it to cash, and then you're no wiser. But it may not always be that kind of portable property. It may be an interest in business. The individual might have gone and buy shares in Massey, or they might have opened up in partnership a construction company with somebody else, or they may own it personally. So the court is also able to put other orders in place so as to safeguard it. But perhaps the most interesting of the kinds of orders it can make is the appointment of a receiver. I've talked about individuals who might clothe their ill-gotten gains with a veneer of respectability by setting up a business, wholesale, retail, car rental, whatever it is, car parts, whatever they are. Now, the question would arise, in attempting to seize the assets, does the Crown go in and shut down everything? No, sir. In the first place, that would be unjust, because you may not succeed, and that individual would have lost the benefit of their investment. So the court has the power to appoint a receiver. And that receiver is very much like the receiver managers that were put into CLECO. Very much, I'm sure everyone here would remember seeing notices in the press that a receiver is appointed. That receiver is appointed to carry on the business, so that in the event that the Crown is not successful, the individual can be handed back a business that is still a viable concern. And the receiver must be somebody who the court is satisfied can carry on the business. But the point is that the corpus of the business is allowed to continue, so that if the Crown is successful, it is able to take the entire business, or if the Crown is unsuccessful, it is able to pass back the enterprise to the individual. I could also mention, Mr. Speaker, what happens when you mix ill-gotten gains with other property. As I said, it can happen quite easily. You can invest and be a part owner of a business. You can add it to your mother bank account and mix it with hers. The point is, the powers of the court allow you to go after those assets as well. So just because you mix your ill-gotten gains, it doesn't mean it's not recoverable. It is as recoverable, sir, as if you didn't mix it. So under clause 75(2), it talks about recoverable property still being recoverable where you add it to a bank account, where you use it in part payment for the acquisition of an asset, where you use it to restore or improve land. As I said, sometimes people will build a house for a relative or fix up the parent's house or brother house or something, or where you use it to discharge a mortgage, or where a person who leases it uses that money to acquire a freehold. And in a situation, sir, where you use the ill-gotten gains to make a profit, the profits are also recoverable. So you can't say that I put $100,000 in the business. Yes, that was money from corruption, but you shouldn't get what that $100,000 bought. Absolutely not, Mr. Speaker. The profits that accrue whether by way of accretion in value or whether it was used to turn over and to create greater wealth, those assets are also recoverable. I've talked about the retroactive effect. I've also spoken about the standard of proof. I'd like to draw your attention, sir, to clause 103. Somebody asked whether the property has to be in Barbados. Doesn't have to be. And therefore, 103, it provides that orders may be made by the court in respect of property wherever it is situated, sir. You know, wherever in this context does not mean whether it is in Eagle Hall, or Checker Hall, or Chance Hall, or Easy Hall. It would also arise where the ill-gotten gains have made its way into a bank account in Florida or in New York or anywhere else. So just because those assets may have made their way outside of Barbados, you mustn't feel that they are somehow preserved and protected. It says wheresoever situated, sir. And that 103.2, it provides in essence that as long as there's a connection between the property and the case, if that asset is abroad, it is sealed, sir. It becomes available to Barbados. Now, what happens to these assets when you seize them? Well, they're transferred to the Crown. They're transferred to the Crown. And the ownership having been transferred to the Crown, sir, then a whole new interesting realm is available. Because the assets transferred to the Crown are now able to be used in law enforcement. And in fact, one of the biggest challenges that we have is the ability to effectively fund law enforcement agencies, not just in Barbados, but across the region. And we've recently signed an instrument at CARICOM which deals with seizure of assets. And that instrument provides specifically that where assets are seized, a percentage of those assets are to be put into a regional fund for the purpose of fighting crime. Now let me try to make this connection for you, sir. While we think of crime in Barbados as being in Barbados alone, I urge you not to be so naive, because the criminal element in Barbados has its linkages all across the region and in places beyond. They have suppliers, they have dealers, they have friends and colleagues and facilitators, and many of them operate outside of our shores. They live outside of our shores. They do not carry a Barbados passport. They may have a Guyana passport, sir. They may be from Trinidad. They may be from St. Vincent. They may be from Florida, London. They may even be from the Ukraine. But please do not fool yourselves into thinking that the criminal element of Barbados operates in some cocoon, and because we talk about hotspots, we feel that they operate only in that hotspot, sir. You can rest assured that there are tentacles coming from abroad that reach in to those hotspots, and there are tentacles leaving those hotspots and reaching out into other territories abroad. So this legislation encompasses the notion that whether the asset is in Barbados or not, we simply have to have the lawful authority to go after it. That's the only way to be effective. I believe that I've also mentioned tainted property, and if I haven't mentioned it before, let me just say that this statute allows for tracing of property. So if you stole a car and sold it, and then used it to buy a boat, or used it to invest in something else, we are entitled, and under law we are allowed to go after that something else. So by virtue of the transformation, it doesn't mean again that it is immune. Doesn't mean that at all. Whatever form you convert it to is also amenable to the operation of this law. And whether, as I said, you convert it solo or whether you mix it in with something else, we are able to go after it. Now, sir, I must also appraise the Chamber of another set of arrangements. This bill is being passed because of the deficiencies that we consider exist in our law. But I must also tell the Chamber that increasingly jurisdictions like Barbados, or perhaps I should say all jurisdictions, are being called to satisfy various international fora that we meet certain minimum standards. And I will say to the Chamber in this instance that the international standard setting body in relation to money laundering, or I should say anti-money laundering and anti-terrorism regimes, is known as the Financial Action Task Force, headquartered in the office of the OECD in Paris. And Barbados is a part of what is called a regional body, the Caribbean Financial Action Task Force. And Barbados has to meet certain criteria in order to be able to satisfy the international bodies, this particular international body, that we meet operable and basic standards. In fact, we need to satisfy them that our standards go beyond. Now, when they did the assessment of Barbados a year ago, they held the view that the existing legislation did not allow us to effectively fight money laundering and anti-terrorism because it was focused on too narrow a band, but also it focused on too narrow a set of circumstances. You had to have had conviction. It had to be related to drug offenses. It didn't cover any of the other potential areas which would be of concern in fighting a money laundering system and strengthening our laws so they can effectively fight money laundering. And the passage of this piece of legislation will therefore serve that added purpose of demonstrating to the international community our commitment to fighting money laundering. One of the ways to fight money laundering, Mr. Speaker, is to be able to go after the money and to be able to do it effectively and to be able to do it in circumstances where you may not have a conviction and to be able to do it in circumstances where it might not be an appendage to any kind of drug activity at all. And therefore, this particular piece of legislation is intended, in addition to settling our domestic arrangements and to bringing them into the modern context, it is also intended, Mr. Speaker, to satisfy some of our requirements for the Caribbean Financial Action Task Force. Now, the bill has a lot of sections, 170, I believe. I wouldn't try to go through all of them. I believe that I have tried to identify a few of those sections that are key to understanding the scope of the bill. But there's one other area that I must deal with. I've spoken about it on several occasions, and it has to do, Mr. Speaker, with something called unexplained wealth orders. The truth is, you can't effectively fight in this regime if you turn your eyes against or in the opposite direction of very glaring things that happen around us. An unexplained wealth order, and we could dissect the term. And if we did, you would recognize that it relates to the power of the Crown to ensure that an individual has in his possession only that which he's lawfully entitled to. And we are therefore putting a regime in place which allows the court, on the application of the Recovery Authority, to look at assets that individuals own, but in circumstances where they cannot explain the source. Now, I'm going to go through this in some detail because I don't want there to be any misconception. One of the challenges in any system is the ability to determine what an individual lawfully owns or not. And in truth and in fact, sir, while we hate to talk about it, the members of the political class are frequently the ones who get looked upon in this area, perhaps justifiably, but perhaps not. There are numerous individuals in Barbados who, you and I know, earn $2,500 a month. Often they work in government departments, but their asset base runs way beyond what their earning capacity would allow for. Now, I recognize, Mr. Speaker, that Barbados is a very private society. We don't like people knowing what we have. We don't like people prying into our business. I grew up in the country, and I know that sometimes you could keep the side door open, but at other times you had to shut it because nobody wasn't to see inside. It is part of the psyche of Barbadians that we preserve our privacy. And I understand, sir, that this unexplained wealth order regime is not going to be one that people will embrace readily. But let me begin by saying this. If you have nothing to hide, then you have nothing to worry about. So let's start with that premise. If you have nothing to hide, you don't have anything to worry about. An unexplained wealth regime, sir, will require that an individual must be able to demonstrate what their lawful income is, and that lawful income was sufficient for the purpose of obtaining that property. That's the essence of it. We all know of instances where individuals are living large, but they have no visible source of income. And perhaps the first set of people that you would think of would be individuals engaged in criminal activity who, when you check the tax return, they've probably filed none. Or if they did, they claim every year that the business suffered a loss. You know that what they're selling does not allow them the amount of revenue that would facilitate the construction of block after block after block after block of apartments and the acquisition of vast sets of real estate and the driving of fancy cars. But because you can't tie them to any known criminal activity, you have to turn your eye away from it. Now, these are difficult times. And I understand that people will worry about Big Brother peering into their business to try to see what they should and should not have. But the system will allow for an individual against whom an unexplained wealth order is sought to explain what that wealth is. Simple. Now, in England, the first case on unexplained wealth was brought against an individual late last year, and it was an individual who had 16 million plus pounds and no explanation for it. 16 million plus pounds, and could not explain to the authorities where it came from. Now everything is evidence-based, Mr. Speaker, because the reason the authorities were able to home in on this particular circumstance was because of the very evident lavish lifestyle. Spending £20,000 at Harrods in an afternoon and going back tomorrow morning to spend another £20,000. Couldn't explain where it came from. Up to now can't explain where it came from, and the Crown said, in these circumstances, the income that you've said you earn cannot explain where this money came from, and in those circumstances we are forfeiting it to the Crown. Now, Mr. Speaker, we're either serious about fighting corruption and so on in our society, or we are not. We are either serious or we are not. When we talk about corruption in our society, we are talking about people who are taking bribes of one kind or another, but they have to put the money somewhere. And for the most part, they will convert it to assets that you and I can see. Don't bury your head in the sand. You know that this individual is working in a government department, and you know what their salary is, and you know what it will cost to procure that particular residence. You know what it will cost to drive that particular car. And politicians, sir, of which the members of this chamber save and except the visitors in the gallery and the staff of Clark, politicians are, I suppose, ready-made for that kind of thing. It's perhaps the life that we expose ourselves to then once we get involved in politics. I was once told that I bought my home after the 2003 election when I won in St. John and became a government minister. I thought that I'd been living in it for 4 years prior, and that I bought it through a series of mortgages and sleepless nights. But the perception went out that I won the election in 2003, was appointed to Owen Arthur's cabinet, and very shortly thereafter procured a residence in the constituency of St. George North. I didn't know. But you know, there's that perception. But that perception is largely fueled by our own fault. It is fueled by that, sir. There are generations of politicians who have lived modest lives. And they died paupers. And there are others who, when they came to government, had a significant enough asset base that allowed them to continue to live the life they lived, notwithstanding that the cabinet salary was and still is rather modest. But there are others who came to government not being able to make their monthly rent. There are others who came to government working in multiple places in order to be able to make ends meet. And they came to government, sir, getting more or less the same ministerial salary as we get now. But in short order, sir, the lifestyle that they present cause people to wonder, well, if this is what you're earning, then how do you afford that? And we think that people are fools. But people in our community see it. And they recognize it. And they ask themselves how these politicians get so. And no wonder they're cynical about the political process, because almost down to a man they think that the political class has come to loot and steal and rob from the treasury. And sometimes we ourselves even perpetuate it. How many times did you hear the last Minister of Finance say, don't let the leader of the opposition get her hands anywhere near the treasury? I heard him say it on many occasions. But you know what the subliminal message there is? It isn't don't let the opposition get her hands on the reins of government. It is don't let her get her hands anywhere near the treasury, as if the treasury is a box somewhere that you could open and push in your hand and take out $100 bill. But it is those silly statements that projects in the minds of the average Barbadians that you and me and the gentleman behind here and to my left, that we're all a bunch of crooks.
Right. We see who the crooks are.
So we bring it on ourselves. We bring it on ourselves. And the people who pay the corrupt politicians, they don't keep it a secret. They meet on the boats and they say, boy, you know how much money I had to get so-and-so?
For a project, for a contract.
New days are with us. And for better or worse, sir, this will go where it goes. And therefore, at clause 136, when we talk about unexplained assets, no, 136, we also mention specifically a genre, a category, a class of people called politically exposed persons, which includes you, Mr. Deputy Speaker. It includes every member of this chamber, every member of the other place. It includes board chairmen. It includes a whole raft of people. The notion of politically exposed persons is no one. I think I heard one of my colleagues say that he went to the bank to borrow money and didn't realize that if he had sense, he would have borrowed before the elections.
Difficult.
Because before the elections, he could have get away with not being a politically exposed person. Well, he couldn't have, because depending on when he went, he might have been a candidate.
Even your children know.
But your spouses, your children are now all politically exposed persons. And I must tell you, it's intrusive. From the last time I wanted to borrow money, they wanted to know my father's mother's maiden name. And I said to myself, thank God my father's still living, because I could ask him. But if my father had died, I do not know how I could possibly have found out what my father's mother's maiden name was. And I still don't know what they wanted to find out about my father's mother. My father's mother died 15 years ago. But the bank wanted to know his mother's maiden name. He told me and I forget, so I hope I hope they don't ask. I hope they don't ask next time. But happily he's still with us, so if you could ask him. The member for St. George North might actually know it. But I stop at the marshals. I can't identify many more than that, sir. But to come back away from the levity, sir, one of the categories of people who are going to be looked at specifically for unexplained wealth is the political class. Now, you know, there's that old saying, to whom much is given, from him much is expected. And we ask for the public's trust. We ask that the public repose their trust in us through giving a vote. And I'm happy that I'm part of an administration that recognizes that we are accountable to the people, not just for the vote, but for things that the vote allows us to have power and authority over. So before you can get an unexplainable authority order, sir, you must, and by you I mean the office, the Attorney General, must be able to establish to the court that there are reasonable grounds for suspecting that you hold the property. So it must be yours. At 2, the value of the property must be more than such amount as may be prescribed by the minister by order. That has not been prescribed and will be prescribed when the statute is passed. But the reason it is by order and not stated here as a number is to take into account of the varying circumstances, inflation and so on, because it would mean that you'd have to come back to court and change, redebate the section to amend. So it is being dealt with by order, which is what happens in other jurisdictions like Dominica and so on. And perhaps more importantly, I've talked about it before, but it's here at A3, that the known sources of the respondent's lawfully obtained income would have been insufficient for the purposes of enabling the respondent to obtain the property. So those are the key. But then you go on, sir, that there should be reasonable grounds for suspecting that the respondent is or has been involved in unlawful conduct. All of these, sir, are in the alternative. So it's about accountability, sir. But as I keep saying, if you have nothing to hide, then you don't have anything to worry about. And you are able to come to court in circumstances and say, I inherited this property from my mother. My uncle died and left it to me. It was family land that I titled in the court. I built this house by mixing concrete and mortar every day, and it took me 10 years. All of these are things that are part of the Barbadian experience. And I don't want us to believe that anybody grudges somebody a nice residence or a nice car, because that is why we work hard for it. But let us make sure that when we get it, sir, we get it honestly. Mr. Speaker, I hope that I have been able to give an insight over the last hour and a half as to how this legislation is going to operate. I expect that it will raise much discussion. This is not a statute that is being brought to create criminals of anybody. It's not that kind of statute. It is simply trying to reorder the existing arrangements in relation to the proceeds of crime, recognizing that what we had in place was not appropriate for today's environment. And the add-on benefit, sir, is that it allows us to show to the international community that we are in a position to meet the highest standards in relation to fighting money laundering and things of that sort. Mr. Speaker, I've perhaps spoken a little longer than I intended. I hope that members will seize the opportunity to engage, and I will, of course, be available to answer any questions that this chamber might want to pose in relation to the bill and its operations. I am obliged to you, and I beg to move that this bill be read a second time.
Member for St. Michael West.
Thank you, Mr. Deputy Speaker. And I appreciated the honorable member's very deliberate way of leading off on this matter over what I think is essentially so a very important legislative mechanism to help us put Barbados on the right track, or keep Barbados on the right track, or get Barbados back on the right track, depending on who's looking at it and how you look at it. I think A measure such as this is very much in keeping with government's stated intention of bringing integrity and transparency and accountability into the realm of public life in Barbados at all levels, and dealing with miscreants both operating in the public and in the private sector as well. And Mr. Deputy Speaker, most crime is motivated by profit. Pursuing and recovering proceeds of crime would send out a message that we cannot allow crime to pay, would prevent criminals from funding further criminality, would remove negative models in our community, and would decrease the risk of instability in financial markets. Those, Mr. Deputy Speaker, are the words of former British Prime Minister Tony Blair with reference to this particular matter. Proceeds of crime and instrumentalities of crime legislation as applied in the UK and elsewhere. No one has to tell us, Mr. Speaker, that one of the biggest threats to developing states is corruption. And the Honourable Attorney General focused on that matter as well. Corruption is rife globally. It undermines developed states. It can absolutely wreck developing states. We have examples, especially so in Latin America. We have examples in parts of Africa. We have a growing number of examples now in East Europe and in Asia. And we have signals that this could be the trend in some parts of the Caribbean. I believe, Mr. Deputy Speaker, you and I and all of those who occupy positions in this Honourable House will want to ensure that this is not the story that is told of Barbados. That it was a place which was rife with corruption, corruption which went unchecked, and corruption which flourished in a context where governments of the day did not see it as part of their primary responsibility to counter such drift towards corrupt and perverse practices which implied detriment to our country. We are a developing state. We have to deal with the reality of actual and potential corruption. Civil and criminal asset seizure, forfeiture, these constitute potent mechanisms for fighting against the scourge of corruption, both in public sector and in the private business world, which is part of our reality. Because civil and criminal asset seizure, forfeiture, confiscation, these things are both preventive mechanisms, because it can stop criminal element in its track or certainly retard their progress and their climb to wealth. It can also be very much punitive with respect to loss of your own personal liberty, but of course with respect as well to deprivation of property. So this is an important thing that we're seeking to do in this House. Corruption will threaten our economy. We are struggling very much now to bring that back on track after the battering of the last several years. Corruption will threaten the integrity of our governance system, our practices, our culture with reference to governance. Small states like Barbados cannot afford that. We have to ensure that we get it right with respect to the governance, architecture, that we build around us and under us, the governance practices that we make a part of the culture that informs how we allow ourselves to be led, how we manage ourselves, and how our institutions are led to develop. Corruption is in fact a serious threat to the integrity of institutions, so we can also ill afford that. Corruption indeed is a threat to the social or the societal fabric of the country. Corruption does not exist in some isolated and vacuum context. It is rife in societies to the extent that those societies are destroyed. And in small spaces such as ours, Mr. Deputy Speaker, I'm trying to say the fragile fabric of our society can easily fall prey to a culture of corruption. So that anything the government of the day, this government, any other government of the day can do to stem that rising tide of corruption, to counter those who are given daily to corrupt practices, to those who build lives of luxury platform on practices of corruption, anything the government of the day can do to address that is to be applauded and it's to be supported. And I think this is a context in which this measure is brought to us by the honourable member from St. Joseph today. Measures like these are platformed on international practice. There are UN and other international conventions that speak to these matters: serious crime and corruption, terrorism, other forms of criminal activity. So that what we're seeking, I imagine, to establish here is further the truth, the reality, that we very much understand our place in the world as a responsible nation state, as a maturing democracy, and that we want to ensure that our legislative platforms and architecture are aligned with those in keeping with what is happening in the international world. We can't only pursue compliance when it comes to OECD strictures on tax policy, but we have to see where the world is going with respect to its response to crime and dealing with the organized criminal element. And we're signatories to some of these conventions. Even among ourselves here in the Caribbean, we're signatories to treaties and agreements that speak to these matters. And so we're, I imagine, seeking simply to bring ourselves and to keep ourselves in line with the best institutional and legislative practices which relate to the matter of addressing organized crime and corruption, and even in our small state space, potential terrorist activity. Now, this measure, as seen by many, is a very potent way of dismantling organized criminal networks, interrupting the flows of the capital that drive that criminal activity. But I want to suggest in Barbados here in this context, and I've said this before, I say it again, I will not raise my voice, but I will say it repeatedly, and I would hope that it catches the relevant and necessary ears. We have to remove the apparent existent bias with reference to investigations and prosecutions in Barbados. There is a real perception that depending on who you are, you will not be fully and properly investigated, if at all. I see you nod your head in the affirmative. That means, Mr. Deputy Speaker, you here in St. George North as well, or wherever abouts you make your wrongs in this country. I understand you have some intimate interest in Brewster Road, in St. Michael West.
St. Michael West.
In St. Michael West. And wherever you may make your wrongs, I'm sure that you hear that because I see you nodding in the in the affirmative. And there is that view that there is not the robust effort at investigation, depending on who you are, and that there is not the robust effort, the ready effort, enthusiastic effort to prosecute, depending on who you are, or who you know, or to whom you are known. And all I'm saying is, one of the things we've got to try to do, even as we bring measures like this to this honorable chamber, and are commended for that, we've got to try to address that matter and remove the perceived existing bias around the matter of investigations and prosecutions in Barbados. It cannot be that if you are of a certain hue, you are investigated and prosecuted. It cannot be if you are of a different hue that you are allowed to escape the eye of investigation or the hand of prosecution. It cannot be, depending on who you know or where you went to school. It cannot be that the place of your birth matters. It cannot be that because you run a business and employ a certain number of Barbadians who are dependent on you, both they and their families dependent, it cannot be that you are allowed to escape the net while others are brought to face the law with respect to their transgressions. So I support strongly the move to dismantle any systems or structures of organized crime in Barbados. I support the move to attack the criminal element in its pockets where it hurts. I support the move to interrupt the flow of capital around illegal activity in Barbados, but at the same time, I say we've got to address the matter of the apparent or perceived bias with respect to investigations and prosecutions in Barbados. The measure is intended, as I understand it, to stop both the profit from crime and the pursuit of criminal activity, because you're dealing with not only proceeds of crime or from crime, you are dealing with the instrumentalities, the instruments used, the vehicles used to facilitate those crimes. In the world in which you live, Mr. Speaker, there may be those who use the bicycle. In the world in which others live, it may be a yacht, a boat, a private aircraft. But whatever the instrument, it may be a business as a front, but whatever the instrument, Mr. Deputy Speaker, my understanding is the intention here of the twofold intention of this measure is to stop both the crime and the profit therefrom and the instrumentality, the vehicles, the means used to acquire gain from illegal and criminal activity. The Honourable Attorney General made a point, and I want to repeat it. I had it here in my notes. And it refers to the fact that even in our small state context, those who are at the top of the chain, of the ladder, those who are at the top of the structure, can make themselves and keep themselves distant from the criminal activity while benefiting more so from the acquisitions through that criminal activity, but they can keep themselves distant from the process, from the criminal activity. So the investigations will lead to the foot soldiers. It will lead to the middlemen. But those at the top can isolate themselves in certain contexts and circumstances such that the eye of investigation does not fall on them. The hand of the law cannot touch them. I think what I hear the Honourable Member for St. Joseph suggesting is that these measures allow us to attack organized crime in such a way that leaders of this criminal activity will now find themselves closer to prosecution, more subject to investigation, because the measures allow for seizure, asset seizure, for tracing of ill-gotten gains. Exactly so, Mr. Deputy Speaker. So that is to be supported, and that is to be applauded. Now, the Honourable Member for St. Joseph also made the point that resources can actually fall to the hand and to the use of the state, especially law enforcement, when seized or forfeited by use of these particular measures. In other words, if you want to illustrate it just loosely, the police may be able to apprehend a man, the Coast Guard I suppose, on our coast, and he's using a boat, speedboat, to transport some contraband. Charged, found guilty. Instrument of crime is a speedboat. Instrumentality is a speedboat, which can now become of good use to the law enforcement, or may be sold by the state, and the funds go to enhance the capacity of the Coast Guard to better do their job. And I support that, and mainly for this reason. I said it last week, week before, in the debate on the estimates of the Ministry of the Attorney General. We need, Mr. Deputy Speaker, and I know you hear well, we need to put more money in and better fund law enforcement and law and order in Barbados. It is all right to fund education well. It is all right to fund health well. These are two aspects of social service that we have identified are very critically important to developing our human capital and hence our national development. But if we do not proportionately fund law and order, all the gains that we achieve through our investment in health and education will fall prey to that incapacity or inability of law enforcement agencies and judicial entities to effectively and properly do the job. So I say again today, we have to find ways and means of better funding law and order in Barbados. And if the proceeds of crime, and instrumentalities of crime can be properly used to supplement the funding going to law and order, then we ought wisely so to use those proceeds. The measure, apparently, and the Attorney General spoke to this, speaks to a situation where property is acquired and is located overseas, but through criminal activity pursued in Barbados. And I had here the note that I wanted to suggest that there's a need for a functional, not simply a legislative mechanism, but one that works, a functional mechanism to treat a situation where property held in Barbados is derived from crimes committed elsewhere and vice versa. So that if you, Mr. Deputy Speaker, I'm sure you will never do this. This is not your failing. This is not at all your area of weakness. I'm sure, Mr. Speaker, Deputy Speaker, it would never be said of you that you committed a crime in Barbados and the proceeds from which allowed you to have some property abroad, or vice versa. But there are those outside of this chamber of whom that perhaps is and will be the reality. We need not only legislatively to provide for a mechanism that treats to that, but we need to make sure that the mechanism which is rooted in the legislative structure is functional. You and I both hear stories, Mr. Deputy Speaker, of people that we know who by corrupt and criminal activity here have properties, and I use the word property in its widest definition, have properties overseas. And the mechanisms that we embed in the law must be functional in reality to make sure that that does not happen. Because I may be aware of the huge house that you have in St. Christopher. St. Christopher is a fictional parish in Barbados. But I may not be aware of the huge property that you have elsewhere abroad. And therefore, what mechanisms we put in this law must be observed to be functional, because we've all known of cases where legislation was good in its appearance, good in its draft and its documentation, but not functional for various reasons in the reality, in the real context. There are some cautions, Mr. Deputy Speaker, that I have, even while supporting this measure this morning, understanding the rationale and basis given by our learned friend from St. Joseph. The discussion around those who have some concerns on these matters relate to the potential conflict relative to one's right to property ownership and the fact that property itself under this legislation becomes a target. The Honourable Attorney General used the legal terms and then said that we were not bright enough to understand them, so he would pass quickly. I'm just teasing my friend. He did not say that at all. Come on. But he used the legal terms with reference to this and passed on. And what we're citing here is the fact that in the measure, the property itself becomes a target and not necessarily the person or only the person. And that's part of the discussion around this issue. That because the target, because the property is the target, the Attorney General used the term in rem, because the property is the target. People have expressed some concern as to the potential conflict between one's right to property and the fact that that property can become a target, and in fact, under civil forfeiture, can be seized even in the absence of a conviction, and in a situation where there may not be even sufficient evidence to prosecute. And that is part of the concern that has to be addressed as we work through this. Is it right to give to the state the power of confiscation in circumstances where there may not be enough evidence to prosecute in a criminal court? So whereas property can be seized, assets can be frozen, you're talking about a context where these things may take place, where there is not even a sufficient evidence that you can prosecute, far less get a conviction. I think that is my understanding of the discussion. In North America, there's a concern as well. We talk about enhancing resources for law enforcement through acquisition of proceeds from crime. But the practice, apparently from what I read, is fairly rife in parts of North America, where in some states there's what is called policing for profit, Mr. Deputy Speaker. Policing for profit. In circumstances where states are constrained in terms of their capacity to finance policing, in circumstances where police departments are bereft of the levels of financing they need for their operations, and this type of legislative measure is used to support police action, is used to support prosecutorial action, so that assets and resources may be acquired and then put to use by law enforcement. I don't think we will ever see that day dawn in Barbados. If it does, it will be a dark day. But it is a concern that must be put on the record, that whereas proceeds from crime and instrumentalities of crime will allow under the law such resources to be given to the state and thereby transferred to operations in law enforcement, that we don't find that the law is misused for that particular unpleasant purpose. Now, innocent persons, by admission of the Attorney General, may be incidentally, or perhaps, and he didn't say this, mischievously caught up in this process. And that has always to be a concern. In a small developing context such as ours, that innocent persons are caught up incidentally by the action, or perhaps mischievously. People know you, Mr. Deputy Speaker, and people put you in trouble. Don't forget, we're talking here about loss of property in a circumstance where you're not necessarily convicted. We're talking about loss of property in a circumstance where you're not necessarily charged and convicted. It is not beyond the realm of the imagination of the mischievous who want to get at you or someone else, Mr. Deputy Speaker, to contrive circumstances such that fingers will be pointed at you, and that which you have legitimately earned and acquired then becomes a target and gets caught up in this whole thing because of a motive rooted in mischief. So there are those who might be incidentally caught up, and there are those who might be mischievously caught up or targeted, and we have to be concerned. Third-party interests, and the Honourable member from St. Joseph made reference to that as well. Third-party interests must be protected. We know the culture of Barbados. We know that sometimes ownership is multi-titled, if you understand what I'm saying. You got a little bit in his, and he has a little bit in this, and she has a little bit in that. You know that, I know that. That is the way we have developed historically and culturally. And one brother puts this in, and the other brother puts that in, if you understand where I'm coming from. And unfortunately, the other brother misbehaves, and you are not aware of his misdeeds. And he gets caught up in a web of investigation of policing and prosecution, and title is in his name, but you have legitimate third-party interests if you understand what I'm saying. Yes, all I'm saying is it's a concern. I know it's in there, and you spoke to it, and I said that. And we have to be concerned about it because this could cause real stress for people. The system does not always work swiftly and efficiently. And until that muddle is cleared up, you are made to face severe stress because simply, incidentally, you have an interest in the matter, and those who hold interest with you have been engaging in activities of which you are totally unaware. And so your innocence may be established after a while, but your property is tied up or lost, and you are deprived of its benefits for quite some time. These are some concerns, I think. We need efficiency in the system to provide for quick dispatch. Our justice system is not renowned, positively so, for its efficiency and speed. So we're going to do this. We need to ensure higher levels of efficiency to provide for quick dispatch in order to offset potential damage and loss, especially to business investment, but also to private interests. Because a man employing 50, 60 people, and he gets caught up in this web, and property is tied up, and capital is tied up, and business investment is stymied. These things will happen, and he may very well be guilty and found later to be guilty. But we have to make sure that the system is efficient such that quick dispatch is the outcome of the procedures. If that does not happen, we're going to interfere with people's investment, and we are going to frustrate people's interests. This relates very much so to the matter of freezing of assets. Now, we need an effective regime for disposal of assets which are seized. And this may not appear to be important to some people, but I believe that it is. If we do not have an effective and transparent mechanism for disposal of seized assets, misuse of confiscated assets, forfeited assets, could become a reality with which we do not want to have to deal or live. We know what life is like in Barbados. And so we have to have a system that manages transparently and efficiently so the disposal of assets which are confiscated, seized, or forfeited. A simple matter of storage, Mr. Speaker, can become an issue. Storage capacity depending on the asset. I grew up in Station Hill, still pass through Station Hill almost daily. You go into the district here compound, you are going to find a large number of vehicles just inside the main gate. A large number of vehicles. I imagine some of them are part and parcel of ongoing investigations and prosecutions, but a large number of vehicles, and there's no space to properly store them. And this, I'm sure, is not, I've seen boats there, I've seen top of the line motor vehicles there, and if we're going to talk about seizure and forfeiture, Mr. Deputy Speaker, we must bear in mind storage capacity until proper disposal can take place. Because if this legislation comes into being, I anticipate that the instrumentalities of crime or associated with crime, and it's not only a house that you will not move, it's not only cash that will be in some bank account, but the other forms of instrumentality which will require proper storage and management. And we've got to think about that. You do not want to know, Mr. Deputy Speaker, that the Mercedes-Benz that they seize from you and lodged at District A disappears overnight, and nobody knows where it has gone because it was right there by the gate, just behind a wired fence. You don't want to know that. We have heard of larger vehicles and other matter escaping from the port without knowledge, and from other places without knowledge. And all I'm saying is, if we're going to go here, you got to bear in mind that we got to build in some of these things. Transparency and accountability have to be the order of the day. This government has boasted much in terms of its move in this direction to ensure that transparency and accountability attach much to public life, much to processes of governance under which we now live and will live going forward, and it has to very much attach to this. You can't go this direction and not be transparent as to what you have seized, what has been forfeited, what are the proceeds of crime, and what was the crime, and who committed it, and who is on the... You can't go this direction if you're not going to be transparent. And high levels of accountability must attach. The Attorney General as well spoke to the fact that crime goes across borders. It's an international thing, it's an inter-regional thing. And I know we are into mutual legal assistance agreements internationally as well as in the Caribbean. And we've got to make sure that, especially in the Caribbean, where there's apparently a lot of organized interstate, interregional crime, that we have functional platforms that can match what we have here in Barbados. Because unless that happens and there's an architecture regionally, then persons here in Barbados may still feel that they can get away with things because there's some deficiency in the platforms, in the architecture, in the systems which obtain in our sister islands. So it calls for functional cooperation. I know one of the areas under Article 2 of Mutual Legal Assistance Agreement speaks to this basic business of seizure and forfeiture and proceeds from crime. So we need to ensure that across the region that the platforms which are put in place are in consonance with what we seek to do here, lest we find that ours turn out for that reason to be deficient. And we have to have, and the Attorney General again addressed this, clear and functional processes with reference to the right of appeal. And the right of appeal in a context where those appeals can be heard as speedily as possible. Because it's one thing to deny people or deprive people of their right to property, period, based on a conviction. It's quite another thing to deprive or deny people right of ownership of their assets and property in a circumstances where there's no prosecution and there's no conviction, and yet the process drags on. So that mechanism of appeal must be efficiently functional. I'm just trying to suggest today, Mr. Deputy Speaker, that this measure brought here by the Honourable Member for St. Joseph, I think, is a step again in the right direction in terms of building up and building out our platforms for dealing with governance and corruption and anti-crime response and law enforcement and so forth. But there are some cautions that I just put to you and to the Honourable House today for our reflection and consideration, and I thank you.
Thank you. Member Honourable for the city.
Mr. Deputy Speaker, I beg to move that the Honourable House be suspended for lunch until 1:45 p.m.
Question is that this House be suspended for lunch until 1:45 p.m. All members in favor say aye. Those against say no. Methinks the ayes have it. This House is now suspended until 1:45 this afternoon.
Yeah.
Say that